And we're here from our Philadelphia office. We are pleased to bring you this special presentation on the Pennsylvania Supreme Court's ruling on Protz and what it means for IREs. If you'd like to view this webinar again, share it with others, or see our other Weber Gallagher University programs, please visit our website, www.wglaw.com, and you'll find copies of this presentation and other presentations from the Weber Gallagher University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. So with that, let's get started since we have a special presentation today. And the title of the presentation is Protz. Where do we go from here? So the facts of Protz are as follows. At the workers' compensation judge level, Mary Ann Protz had a right knee injury in 2007, and eventually the employer requested a IRE be performed under the 6th edition. That was done, and it came back at 10%. The employer then filed for a modification of benefits under the IRE provisions, which was granted by the workers' compensation judge. The claimant appealed to the WCAB, and one of the arguments that she raised was a constitutional challenge against the IRE provision. The WCAB affirmed the modification of her benefits from total disability to partial, and then it went up to the Commonwealth Court level. And the Commonwealth Court decided the case on September 18th, 2015, and it was an en banc decision, which means it was the entire court. Normally the Commonwealth Court sits in panels, but this was the entire court. And what they made a determination and a holding on was that they ruled that the portion of the act which required the use of the most recent edition, that's the language used in the act, of the AMA guidelines was an unconstitutional delegation of legislative authority. And what Commonwealth Court did was they remanded back to the workers' compensation judge to resolve the matter under the 4th edition of the guidelines. Keep in mind, Protz, the workers' compensation judge, used the 6th edition.
So the case eventually goes up on appeal, and the Supreme Court of Pennsylvania wants to address the constitutionality of the general IRE methodology using the 6th edition of the AMA guide, and just the constitutionality of the IRE system in general. So we waited a long time for the Protz decision. You see the Supreme Court took it on March 22 of 2016, and we anxiously awaited the Supreme Court's decision, and I think anxious is probably the correct word given what the Supreme Court did, because the Supreme Court held, I don't know why I'm smiling, the Supreme Court held 306(a)(2) to be an unconstitutional delegation of authority. That was part one, meaning that it was improper for the legislature to use the language, the quote, most recent edition of the AMA guides, because when that section of the act was enacted, the 4th edition was in play, then the 5th edition, and as of the time of the Supreme Court's decision in Protz, the 6th edition was in play. That's different from, for example, the Pennsylvania hearing law statute, which says we utilize the 4th edition of the AMA guides. But then the Supreme Court sadly went a step further, and that's really why we're here, I think, because they declared the entirety of the IRE section under Section 306(a)(2) to be unconstitutional. So that's really the question, given the fact that the Supreme Court said this entire section of the act is now unconstitutional. What do we do now?
Right. So sort of to summarize, the Protz court voided the entire impairment rating system. That's sort of the equivalent of a legal bombshell when you knock out a whole system which has been in place, Dave, for 21 years.
Right. Act 57 went into place in, I think, cases on or after June 24th of 1996, the IRE provision applied to.
Right. I mean, 21 years is a long time, even by our standards. And the Protz court didn't specify how the new rule would be applied, which is one of the things that we're going to talk about going forward. But this is sort of a major problem, and it really gives uncertainty to employers, insurance companies out there about how they're going to deal with their inventory of cases. Interestingly enough, the day after Protz comes out June 20th, the next day, June 21st, the Bureau of Workers' Compensation announces that the Bureau will no longer designate physicians to perform IREs going forward.
That obviously makes sense in light of the fact that the section was deemed unconstitutional. Interestingly, taking a step back, if you remember, for those of you who were doing this stuff back 21 years ago when Act 57 came out, the Act indicated, I believe it was in the Act or in the regs, that the IRE section was only going to apply to injuries that occurred on or after June 24th of 1996. So at that time, we had some guidance as to whether the IRE provision was going to be applied prospectively only or retroactively. We learned it would only be applied prospectively only. There isn't that guidance here.
Right.
And we'll talk about that a little
Right.
more.
The court is completely silent on that issue. And Dave and I were talking before this webinar about kind of how to present this part of it, but we don't want to get into a big constitutional analysis. But there are kind of two concepts that are going to be driving this. One is the Latin phrase void ab initio, which means as though the law never existed. And when you strike down, like a court strikes down a whole section and deems it unconstitutional, what we're kind of dealing with in some sense is that it's as if the law has never existed. The IRE provisions have never existed.
I hate that.
Yeah, I know. I hated Latin, by the way, when I was in school. So it's a problem. So that's one problem that we're going to have to be grappling with. The other problem, and this is sort of a big question, is there a retro application in full or in part? And when we were getting ready for this webinar, we reviewed a lot of case law, and courts have said that this type of issue is one of the hardest issues that appellate courts have to deal with. Whether there's going to be a retroactive application in full or in part, or it's going to be prospective. And one of the languages, in the courts, and not to kind of get into the weeds, but there was a piece of language that said, the past cannot be rewritten. And when you're dealing with an IRE situation where you have 21 years of old cases, I think that's going to be a logistical nightmare for a lot of situations, and something that we're going to have to really navigate through carefully. So that's one of those are the two concepts going forward. So the next question is, where do we go from here? So what we've done is we've tried to arrange this going forward into different categories or buckets, so that if you have a fact pattern, perhaps it'll fall within a bucket, and then we're going to give you some advice going forward. We're going to make some recommendations that are designed to give you guidance and avoid possible penalty petitions, possible quantum merit, situations, and to kind of guide you. But it's certainly uncertain where we're going to go in the future. But this is what we're going to do, right? So the first category is pending IREs, and those are ones that are just completed, or IREs that are just requested, or even ones that are coming up on the 104 weeks, and the window, under the old days would have opened, and they're going to be requested. We're going to recommend that those be stopped and withdrawn. Nothing new from this point forward. It's important for those cases that you explore other traditional options of reducing exposure. For example, being on top of sending the VOE forms, looking at situations where you might have a new IME opportunity. You get 2 IMEs in Pennsylvania per year. Looking at vocational, traditional vocational under Kaczynski, or vocational under a labor market survey is really going to be something going forward that's going to be important until either the General Assembly or other courts weigh in on the impact of Protz. Look at your time of injury employer and see if you can make a job offer. And also, lastly, under traditional options, it's really, I think, a good time to look at some of these cases for possible settlement. the typical case where we're dealing with an IRE is a situation where the claimant has received TTD benefits for 2 years. In those kinds of situations, what's the probability that we're going to get an opinion of full recovery and be successful down the road? Probably not as great as a situation where a claimant is only receiving TTD benefits for 6 months or a year. So right now, for those new cases, explore traditional opportunities.
And I think it's time to get a little creative here. We've lost the opportunity on these new cases to use the IRE as the limiting factor that we would have used in the 500-week scenario. So we don't yet know if claimants' attorneys are going to use this as a mechanism to try to start increasing their demands. They may or they may not. If they don't, then you're sort of status quo in your settlement analysis. And as Chris said, you posture these cases for settlement. The question is, if the claimant's attorneys start becoming unreasonable, what do you do? And I think that's where voc becomes really important now. And when I say it becomes really important, it's not that it wasn't important before, but in a lot of these cases, for example, if you had a high average weekly wage, you might just say, look, why bother spending the money on voc when you can cap the 500 weeks with an impairment rating evaluation? I would get really aggressive with vocational placement in cases where the other attorney is being unreasonable and do things that maybe we haven't done before. For example, let's say our doctor gives you a light duty release, our IME doctor, and doesn't really believe all of the complaints that claimant is providing. Maybe go back to that doctor and say, hey doc, what if you believed everything the claimant said? What if you believed every complaint? I know you don't. I know you found positive Waddell's, but let's say you believed everything. Would you still give caps? And if so, what would they be? Absolutely. I'd give sedentary caps then. I wouldn't do light. I'd make sure the person could sit, stand, and walk around. Maybe then you give the judge another window to limit the exposure to 500 weeks, because that's really all you're trying to do is, if you have an unreasonable claimant's attorney, think about ways that you can get those 500 weeks ticking and get back to where claimants' attorneys were settling the cases when we had the IRE mechanism.
Right. I think one of the things that and Dave raises a good point, that what the IREs did for us is it gave us certainty, but almost too much certainty, such that we lost the ability, I think, to really explore fully all these legal defenses that we have under the Workers' Compensation Act, including looking at those job offers and really putting it to the claimant's medical doctors and saying, he's not totally disabled, is he?
Right.
No. There is something he can do, right? Yes.
Right. That's right.
Even sedentary, yes. Where you start to get into the, those cases that we used to have where the people would come out and put computers in people's homes.
That's right. The funded employment, the Catalyst company that put computers in it. All of those things come into play now. If it's a case that you can't settle for the number you want because you have a claimant's attorney who says, I've got Protz and you have no way of limiting stuff, and now what are you going to do? So we need to be creative, think about those options, get aggressive, and make sure that we're not settling these cases for bigger dollars than we were. There may be the aberrational case where the claimant is just completely, totally disabled, and maybe we could have gotten a 45% IRE before, and now we can't, and okay. But in the vast majority of the situations, I think as long as we're creative, we're status quo, or we hopefully are status quo in terms of where the settlement should lie.
Right, exactly. So let's look at the category number 2, which we call cases currently in litigation. And those cases are situations where we have petitions for modifications or suspension petitions pending based on IREs that have happened, but there's been no workers' compensation judge determination on whether or not we're going to get that relief. So it's our recommendation that we're going to have to withdraw those petitions before a workers' compensation judge, if appropriate. If appropriate, we have so many different fact patterns going on with these IRE and Protz cases, but we want to avoid, the legal expense. We want to avoid the potential for penalties. We want to avoid quantum merit. We want to avoid excessive litigation costs. If it clearly appears that this is a dead situation, we want to withdraw those petitions. However, we don't want to just withdraw them for the sake of withdrawing them. We want to try to give you some kind of creative argument or protection. And what we came up with was exploring using a supplemental agreement at a workers' compensation judge level to put in a provision into the supplemental agreement to protect the employer's argument that future legislative change can be applied retroactively. And Dave, why is that so important?
We just don't know what the future is going to hold. Like I said, when Act 57 came out, there was specific guidance for us indicating that the statute was only going to be applied prospectively for injuries on or after June 24, 1996. We don't know what the legislature is going to do. They could enact something completely new and different. We don't know if there's going to be some guidance somewhere. It's going to say that this case only applies prospectively for injuries on or after a certain date. And we just want to make sure that someone is not making the argument that because you didn't preserve your right to argue the retroactivity, whether by supplemental agreement or even stipulation before the judge, or even if the claimant's not going to sign the stipulation or supplemental agreement and you have a case in litigation. So make a record before withdrawing the petition. Just do something. I don't think that if something comes out saying it's going to be applied retroactively, Chris, that we have a problem.
Right.
But by the same token, I don't even want a claimant's attorney to be able to make the argument that you didn't do anything to preserve that right.
Right. I think that's right. Best practice would dictate that we make some kind of record.
Okay, so
this is sort of a continuation of where do we go from here?
Sorry, I thought we were going into Category 3, but this is a continuation of Category 2.
Things that are in litigation still, but at a different level.
Right. So cases that are on appeal, I think there's two categories, okay? If it's a non-Protz issue, and you're just arguing the validity of your impairment rating evaluation,
right.
You're saying, we have a 42%, they say it's 51%. They're saying the claimant was not at MMI. Anything that goes to the validity of the IRE in general. Same situation, withdraw with a provision that you maintain the right to re-argue in the future retroactivity. However, if it's a Protz issue that was pending below, because we don't know how Protz is going to be applied,
right.
Those cases should stay. So you don't withdraw. You want to be able to continue and allow a decision to be issued on those.
Right. So we talked about the lag time between when the Commonwealth Court issued its decision in the case and when the Supreme Court made its ruling last week on Protz. And during that lag time, claimants' attorneys filed, I'll call them Protz challenges. And those are the types of cases that you're talking about, right?
Right. I mean, once the Commonwealth Court came out with Protz, we saw a lot of petitions where, I mean, I have two in my inventory where the claimant had been on a partial for 6 or 7 years. And this is interesting. So I got two petitions for reinstatement, okay? In one of the cases, the judge said, Dave, you lose because of Protz. We appealed. In the other case, the judge said, Dave, you win because claimant's counsel didn't timely raise the Protz issue. It's been waived. The claimant had to raise that issue within a certain period of time, within 60 days. There's case law that talks about that. And because the issue wasn't waived, and because there's a Commonwealth case called Winchilla that says if you don't raise it timely, it's waived. Anyway, both of those cases are on appeal. I won one. The claimant won the other. We just don't know what's going to happen. And some of those cases, I mean, we had 7 years of partial disability paid towards the 500-week window.
Right.
We don't want to give up those 7 years unless someone tells us we have to.
Right.
And then there's the other one where I sort of alluded to that, and this is the second bullet point on this slide, and that's where we win below and the claimant appeals, same issue. Take a wait-and-see approach because we don't know if the case is going to be applied retroactively.
Right.
Now we're on Category 3.
Category 3. and sort of like maybe like a hurricane, right? You know, you have categories of different kinds of hurricanes.
Although these are actually going the reverse
The
way.
reverse.
Category 1 is the worst,
Worst.
and Category 5 is the
This
best.
is a reverse category
Right.
case. So category 3, the third bucket is what we called inventory cases. And these are cases not in litigation. And the first bullet point is finalize cases via workers' compensation judge decision with no appeal. The IRE clock is running. And in those cases, we are recommending a wait and see approach under the idea of collateral estoppel, res judicata, the fact that the claimant should not be entitled to a second bite at the apple, which is kind of an outgrowth of the Riley case, which has been decided by a Commonwealth Court before. Those cases, we're recommending a wait and see approach. We want to kind of let those clocks run out and keep those going to see what the General Assembly does, to see if there's any new decisions from the Supreme Court or Commonwealth Court clarifying the possible retroactive application of Protz as applies to IREs. The second bullet heading is unchallenged notice of change cases or supplemental agreement cases. Keep in mind that there are a few cases out there where the claimant actually agreed to change the characterization of his or her benefits through a supplemental agreement that was possible. That's where IRE clocks are running. And again, we're taking a wait and see approach on those. Again, raising that argument if necessary of res judicata, collateral estoppel, and the Riley case.
And also, when that IRE clock is ticking, those cases can potentially transform into Category 4 and Category 5 cases, which we're going to talk about now.
Right, and what I'd recommend for the Category 3 cases is sort of similar to the Category 1 cases where you're exploring settlement, you're exploring using the IMEs, you're exploring using vocational, you're exploring looking at claimants' medical and seeing if there's a work release to see if you can get some kind of petition going under a sedentary job offer. You have all those traditional means available for you as well. So that would be the Category 3 cases. Category 4.
Right, so Category 4, and when I said Category 3 can turn into a Category 4, Category 3 is where the 500 weeks has not expired. If claimant does nothing and the 500 weeks expires and you stop paying the partial, which you should, granted there are some concerns there given that, and hopefully by that time you'll know whether there's retroactive application or not. But if the 500 weeks have expired, there's case law out there which says that in order for claimant to get back on total, the claimant must show a change in status, show that his or her physical condition has worsened. And that's not Protz. That's something totally different. And that's in Section 413 of the statute, and that's in established Pennsylvania Supreme Court case law. So the case is Stanek, S-T-A-N-E-K, for all of you Supreme Court buffs out there. But anyway, same situation. Again, Category 4 is better than Category 3, but there is this sort of gray area here because we don't know, in addition to not knowing what the court is going to do on the retroactivity, we also don't know what a court's going to do where the 500 weeks has expired and whether or not that bucket or that Category 4 is going to be treated differently from Category 3 and Category 2 and 1. Claimant still has the argument that the basis upon which you modified claimant's benefits from total to partial no longer exists. And if someone tells us that that's the situation and you can never take a partial based on any IRE, no matter when it was done, then so be it. But until the court, the legislature, somebody tells you about that, you have your arguments and you must maintain them.
So we have another category, which we'll call, well, so these two slides are just, to kind of confirm that no automatic reinstatement because no definitive answer yet from the courts, is what David said,
Yep.
and that courts are prone to surprise us. 21 years to rule Section 306A2 unconstitutional. That's kind of a legal surprise, I think.
Right. And is the court going to say, we don't care that 1,000 new petitions are going to be filed? Right. We don't care about that. We're going to allow all of that to take place, no matter what the arguments were below, no matter who waited how long. Could it happen? Yes, but the reverse could happen too, which is why in certain situations you just need to stay the course for now.
Right.
So, lastly, in terms of the categories, I'm sorry.
There's two more.
I'm sorry, two more. There's category 6 too. I'm sorry, category 5, and this is totally separate because once 3 years goes by following the expiration of 500 weeks, the 500-week window is called a statute of repose, and that means that you lose all of your rights and all of your remedies. Well, if you lose all of your rights and all of your remedies, and there's no longer even this remedy of reinstating from partial to total again, what remedy do you have? And have you lost the Protz remedy by virtue of the expiration of the 500 weeks plus 3 years?
Right. And I think this is clearly our strongest argument for these category of cases at this point. Would you agree?
Yeah, I mean, the reason why we did it this way is to go from 1 to 6, because I think 6 is even better than 5.
Right.
But going from 1 to 6 and sort of giving you the different categories, or I like to call them buckets of cases where you have no argument to where you have your best argument.
Right. So the last category are settled cases, and settled cases in the sense of a compromise and release agreement has been done on a case. So we have a fact pattern where the claimant did have an IRE, it came back in favor of the employer, and maybe as a result of that, they decided to settle their case, and they settled their case, and there was a decision issued, and there was no appeal. And what about post-Protz, where we're looking at the potential that a claimant or a claimant's attorney comes back and tries to reopen their settled cases? We certainly know under the Commonwealth Court decisions, the Supreme Court decisions, that it's a very high standard to reopen a compromise and release. There has to be some kind of abuse of discretion, material mistake of fact, fraud, or concealment. I think the only case that I'm aware of that actually was successful was kind of the case we always talk about where the claimant had limited vision, and they established that he didn't read the CNR agreement.
Yeah. There's one more, I believe, where had to do with claimant's medical benefits, like the group health benefits, and claimant didn't realize that he was actually losing, or she, I don't remember if it's a man or woman, if he or she was losing the group health entitlement as a result of the CNR. But yeah, there has to be a mutual mistake of fact, and everyone sort of needs to be in the dark. And when you have a law like this, you're sort of assumed to have known this was the law, even though this wasn't the law, which is why it's going to be really, really difficult.
Right. So for those cases where the claimant comes in and he argues or she argues that they weren't informed about Protz, making their cases potential lifetime claims, and you're looking at a possible petition to set aside a CNR, you have all these arguments that, this is a final situation, no appeal. You argue waiver. You argue Protz doesn't apply. You argue that the matter cannot be reopened. I think you have another argument that what this is more of a matter between the claimant's attorney and the claimant, and not a workers' compensation situation. And it was funny because I was looking it up, and there is a case out there from the Superior Court that says there's no cause of action for legal malpractice following approval of a CNR agreement unless the plaintiff proves fraudulent inducement to settle his workers' compensation case. So even in that situation, we might have the claimant being sort of without a remedy. But clearly, CNRs are very powerful tools. We do not predict that the claimant will be likely to reopen a CNR going forward in a post-Protz world.
I don't even predict, and I hope that I'm correct, I don't even predict that we're going to see these cases, because I think it does really open up the legal malpractice situation, and claimants' attorneys, I think, would be very, very foolish to raise the issue that they should have done something and didn't. They could have even put something in the CNR agreement saying that if the IRE section is deemed unconstitutional, we reserve the right to reopen the CNR. And no one's ever done that.
No one's ever done that.
Right. Well, no one to my knowledge has ever done that. Anyway,
it's never been in any of my CNRs. But it's the possibility, and Dave, has an opinion. I think there's going to be some really upset claimants out there who have recently settled their cases, and they're going to say to their attorneys, or they're going to say to another attorney, hey, wait a second, I settled my case for X. All of a sudden, Protz comes out. It makes it, I could have a lifetime claim. I think my case should have been worth Y, and this is a problem, and I want to sue somebody. And I think you're going to see that. I really do.
We'll see.
So we'll see.
To be determined.
I also think you're going to see, the legislator taking a look at this again. Keep in mind, one of the things that when it was passed in 1996, it was designed to help the business community because of increasing rates, and the legislature wanted to give us certainty and also, predictability. And I think those two elements now are taken away from the equation. So when you make the business community make it more expensive for businesses, I think that's bad in Pennsylvania. I think the legislature is going to be forced to deal with this in some fashion, and hopefully they can construct a new IRE provision which will pass constitutional muster.
And I know that there are some claimants' attorneys who are concerned with what the legislature might enact, who are discussing putting some sort of proposal together, which I forget which state it is. I think it might be West Virginia, because these were some Pittsburgh claimants' attorneys that I was speaking with, who were saying that one of the neighboring states, whether it's West Virginia or Pittsburgh or Ohio, uses an 18% IRE provision. And we already know, although who knows if the hearing loss section could be challenged on constitutionality, we know the hearing loss section uses the 4th edition of the AMA guides as the backdrop. So claimants' attorneys could suggest a utilization of the 4th edition and utilization of a certain number. Who knows what the case may be, but I don't think that we have heard the last of this. We certainly haven't heard the last of it from the courts, because we know there are cases that are still going to be issued, cases still going to be decided, and I think that there has to be some sort of guidance on the retroactive prospective nature of the decision, because otherwise the judges can pretty much do whatever they want across the state.
Right. Which is not I mean, that's one of the problems that the Supreme Court has addressed in these retroactive cases, is that you don't want inconsistent results in different cases. It's not good for judicial economy. It's not good for the underlying foundation of the system. So we want certainty. So at that, we'll leave it at that. And thank you for attending our webinar, the Pennsylvania Supreme Court's ruling on Protz and what it means for IREs. If you have any additional questions about the Protz ruling, please contact myself or my partner, David Green. In addition to special presentations on breaking issues, we offer monthly webinar presentations on workers' compensation legal issues. And our next program will be actually July 18th from our Pennsylvania office, and that is entitled Everything You Need to Know About Subrogation But We're Afraid to Ask. Our Pennsylvania attorneys will discuss how subrogation works, including Section 319 of the Act, looking at third-party subrogation, accrued liens, future credits, what is recoverable, and third-party settlement agreements. They will also discuss how to use subrogation to your advantage in possibly settling a workers' compensation case. So you can learn more about this program and all other Weber Gallagher programs at www.wglaw.com/WG-University.